When it comes to shielding your personal assets from being used to pay off business creditors, the formation of a limited liability corporation is a vital initial step of the process. However, the liability protection afforded by a limited liability company is not absolute. In order to provide yourself with the highest level of security feasible, you will need to devise a strategy for protecting your assets via an LLC. Understanding an LLC's limited liability protection. The formation of a limited liability company, LLC, results in the formation of a new business entity that is legally distinct from its owners. The protection that this separation offers is referred to as limited liability protection. In general, if the limited liability company, LLC, is unable to pay its debts, the creditors of the LLC have the right to pursue the bank account and other assets of the LLC. There is no risk to the owner's personal assets, which include their homes, automobiles, and bank accounts. Only the amount of money that the owner of a limited liability company, LLC, has invested in the company is at risk. However, as is the case with the majority of things, there are exceptions. It is still the owner's responsibility to pay off any obligations that they have personally guaranteed. Payroll taxes that have not been paid could be owed by them. If they have failed to conduct their limited liability company in the appropriate manner, they may be held accountable under a doctrine known as alter ego, and if they are sued for their own crime, they are responsible for the consequences. Despite these restrictions, limited liability companies, LLCs, offer a beneficial feature known as liability protection, which plays an important role in the asset protection techniques you employ. To help you get the most out of it, here are some suggestions. Obtain LLC insurance. In the event that someone brings a lawsuit against you, accusing you of misconduct, whether it be improperly maintaining your building, destroying the company van, or deceiving a customer, your limited liability corporation will not prevent you from receiving personal liability. And the verdict in a case for personal injury might be extremely detrimental to one's financial situation. Because of this, it is essential to have a solid liability insurance coverage that will protect not just you but also your company in the event that you are served with a lawsuit. Maintain your LLC as an independent entity. When shareholders combine their personal assets with those of the corporation, they run the risk of being held personally accountable as the alter ego of the corporation, according to the principles of corporate law. This kind of obligation has also been reported to be extended to owners of limited liability companies by certain courts. It is essential to keep the records and finances of the limited liability company, LLC, fully distinct from the personal funds of the owners in order to eliminate any possibility of alter ego liability. The limited liability company ought to have its own bank account as well as credit cards. Important documents such as contracts, invoices, purchase orders, and other documents should always bear the name of the limited liability company, LLC, and should be signed on behalf of the LLC. Through this method, all of the individuals with whom you conduct business will be aware that they are dealing with a separate corporation and not with you personally. Establish LLC credit. A significant factor that contributes to the fact that owners of small businesses are held accountable for the obligations of their companies is the provision of personal guarantees. If you personally guarantee a loan or a lease, you are agreeing to make payments in the event that the limited liability company is unable to do so. It is possible that you will be requested to use your home or another significant asset as collateral for a company loan in certain circumstances. It is possible that the creditor will pursue your personal assets in order to satisfy the debt in the event that the LLC fails to fulfill its duty. If your company is just starting out, it is highly likely that you may be required to personally guarantee significant transactions. Through the establishment of credit in the name of your limited liability company, LLC, the timely payment of your bills, and the demonstration of a track record of revenue and profit, you may be able to avoid some guarantees in the future. Keep just enough money in the company. Generally speaking, your personal assets cannot be utilized to satisfy a creditor in the event that your limited liability company, LLC, is sued. However, the money that is contained within the LLC can be used to do so. It makes sense to keep as little money as possible in the company, and pay the remainder to the owners in order to reduce the amount of vulnerability you are exposed to on the job. Nevertheless, there are a few significant restrictions that apply to this proposition. It is possible that the transaction will be considered a fraudulent transfer if you already owe money to a creditor and then move money out of the organization. In addition, if you fail to maintain sufficient funds within the company to cover its expenditures, a court may hold you personally accountable on the basis of an alter ego theory for undercapitalizing your business in an attempt to mislead business creditors. Explore strategies to protect assets from personal creditors. In the event that you are sued for personal wrongdoing or as a result of a personal guarantee, your personal assets may still be at risk for LLC commitments. This is something that has been mentioned. It is possible that there are ways to safeguard part or all of your personal assets against legal claims of this nature, but this will vary depending on the state in which you reside. You are able to place assets into a trust that is protected from creditors in certain states. However, in most cases, you are required to do so several years before there are actual judgments or obligations that have not been paid. It is possible that certain of your assets, such as your principal residence and the money you have in retirement funds, will be safeguarded from creditors automatically. In order to assess whether or not you are able to structure your assets in a manner that will further shield you from liability for business obligations, you may seek the advice of an attorney who specializes in estate planning and or bankruptcy litigation. The protection of assets LLC, keeping your personal money and business finances separate and ensuring that you have adequate insurance coverage are two tactics that might assist you in protecting your personal assets from creditors of your business. Despite the fact that there is no such thing as complete protection, making preparations in advance can help lessen the risk that you face.